We simply cannot allow people to pour into the United States undetected, undocumented, unchecked.
And complete the dang fence.
This bill that we will sign today is not a revolutionary bill.
Cast down your bucket where you are.
We come from France.
And I am, adamantly against illegal immigrants.
They're coming in by the thousands, just unbelievable.
A wall is an immorality.
Who are you rooting for?
Those masters of the universe are at it again.
They're not sending their best.
You maniac! You blew it up!
Welcome to Parsing Immigration Policy, the podcast of the Center for Immigration Studies. My name is Mark Krikorian, Executive Director of the Center. This time we're going to be getting an update and talking about a new lawsuit that the Center is involved in based on the National Environmental Policy Act, NEPA, which is an important tool in trying to prevent the kind of lawless opening of the border that we saw under the Biden administration. And the Center won the first ever case based on NEPA against immigration actions. This is something that we're going to get an update on from our Director of Litigation, Julie Axelrod, but also on a new lawsuit we filed and sort of what is the context of NEPA and immigration. And in fact, there's been a development in that regard we're going to talk about that the Center is not involved in, an unfortunate development. So Julie, thanks for coming in. And I'm not sure where we want to start. Maybe just start with what's the news on the lawsuit that we have helped file.
So we helped file Rodriguez versus DHS in Texas, which has all Texas plaintiffs. And this is basically a continuation of trying to properly apply NEPA to immigration because it never has been. There's only one context where DHS and INS before it ever applied NEPA in immigration, which was, again, that gets to the lawsuit that we're not involved in, Alligator Alcatraz. So it's always been the case that INS before DHS and still DHS said that NEPA applies when you build a detention center for immigration.
And specifically, the way it applies is that the government's required to do some kind of environmental impact analysis before they take a step that's going to affect the environment. And in the immigration context, that means population, at least for our purposes.
Well, so that's the big issue, actually.
Right.
So what happened with NEPA when NEPA was passed in 1970, population was considered the premier environmental problem. And that, to some extent, that's still true in the sense that the more people you have, the more those people will impact the environment where they live. It's just sort of common sense. But in the 70s and 60s, I mean, people were really worried about overpopulation in a way that they're not currently worried about overpopulation. I think because they thought we can't handle the population growing. And people now have sort of settled into like, well, you handle it by living in a different way. But one thing that the studies would talk about when NEPA was passed was that if you have a larger population, you really have to have more environmental regulation. So like if you have a whole bunch of people who want to fish in a certain place, you have to give out licenses. You can't just say anyone can fish there because everyone will fish there and there'll be no fish left. So it's still the case that the bigger the population, the more you have to think about the environmental impacts of the place you live. And, it's just that they used to believe, and some people still do, that the planet had a carrying capacity. And if you exceeded the carrying capacity, doom would follow. Now there's some people still think that, some people don't. But that's really kind of beyond the scope of what I'm doing, which is the fact that you would have thought when they passed a law, that was NEPA, that basically said, because of population growth, agencies need to think about the environmental impacts of their actions.
If those actions result in increased
environmental
population, right?
Well, yes, including increased population. So you would kind of think, given that the law was passed out of concern for population growth, and given that it was always applied to things that increased population, you would have thought it would have applied to immigration directly, which is the one time when we basically have a government policy of increasing population growth, at least in the short term and directly, because that's literally the government increasing the national population. So you would have thought that, but you would have thought wrong, because in fact, it got applied to all sorts of things, such as mostly infrastructure growth, energy and infrastructure, basically the things we need to build because of population growth. And yet they just ignored immigration and how that creates population growth and how that creates the need for all the infrastructure. I mean, not all together, but if you have people coming in to the country and settling in, you are going to have to expand the infrastructure, both energy and physical, homes, sewage,
that's
everything.
that's actually a good point.
To meet it.
That's actually a good point in that the environmental impact analysis is done for all of the things that are a result of increased population, except the government's artificial direct role in increasing the population. So anyway, that's the basis of our litigation. You won the lawsuit, and we did a podcast on our victory, which is still kind of in the works, and maybe you can give us a little update on where that is. And we have a new lawsuit now. So maybe the thing to do would be to talk about where the first lawsuit that we won, which is the first ever, and how that's different from the lawsuits that are trying to stop expansion of Alligator Alcatraz using the same law, but, obviously very different perspective.
Sure. So what happened in Massachusetts Coalition for Immigration Reform versus DHS, which was the case we won the first victory in. We won a victory almost a year ago now, where the judge said, in the context of the border wall and the termination of the Remain in Mexico policy, that violated NEPA to not do any NEPA, and that our rancher on the border had been directly harmed by those policies environmentally.
And to be clear, it's not building the border wall, it was stopping building the border wall by the administration.
Exactly.
In other words, those Biden policies resulted in more immigration. And whether, those were bad or good, I mean, I'm against them. But the point is that the law, our contention was the law required that they had to have done environmental analysis before making those decisions, because they were going to result in more immigration, and they didn't do that.
And they didn't, and the massive part of the lawsuit was actually about standing, and the judge found that an Arizona rancher who lived on the border, who was one of our plaintiffs, did have standing because he was impacted by that increase in immigration,
right,
in an environmental sense. So there was more trash on his property. There was, a decrease in safety for him. So it was an environmental case and an environmental standing, and he could really prove that those policies were what did that to him.
Right.
So that was why he got standing.
So we won the case, and so now it's all over, right? It's all fixed?
So no. So what happened was the judge said last September, right before the election, well, you've won, but what should I do? As in, what should the court order as a remedy? So in NEPA, remedies really go up and down the gauntlet. Sometimes a court will say, you won, but it's too late to do anything about it, so I won't do anything about it. But bad agency, you did break the law. Bad, right? And which is what DHS wanted the judge to do in this case. So don't order a remedy, just say, fine, you learned your lesson because you were told you broke the law. And that's enough. And so we did a briefing on remedy. I asked for basically the traditional remedy, which is to vacate the decisions, and then I said, order the analysis now. But then And then we finished that briefing during the Biden administration. And of course, then we had a change in administration. And now the Trump administration wanted to restart the wall and wanted to redo the Remain in Mexico policy. So, I mean, the judge sort of was like, well, is there anything left? What should I do now? We had mediation. That did not lead to anything. And then the judge said, we'll have another briefing about what's left. And we just finished that. There's also been some developments in NEPA land that have nothing to do with this case. There was a new Supreme Court case on NEPA. The first one it's taken up in 20 years. And then the Trump administration decided to take away the NEPA regulations that are done by the Council on Environmental Quality because a judge in the DC Circuit had said, it's not legal for the Council on Environmental Quality to do binding regulations on agencies. So what the Council for Environmental Quality is, it's not an agency. It's basically an office in the White House that was created by the same law, by NEPA. And it said, a CEQ, they call it. That's the acronym. CEQ tells agencies, gives them advice. So we're kind of in a new moment on NEPA where we're kind of going right back to the beginning, back to the studs of the statute itself. So anyway, we briefed that. I do not actually think and I made the case to the judge that neither of those things really change anything in our case because our case is such a basic case. We're basically saying, look, here's the statute, and you completely ignored the statute. It's not really about whether you followed the regulations, which are no longer there, because you didn't follow the statute itself. There's also the Supreme Court case was also really not about the basics where NEPA applies. It was about the idea that in infrastructure cases, you can't go absolutely wild as a court. So what happened was there had been a railroad and they were going to build 77 miles of this railroad. And they did a 4-year environmental impact study that was like 3,000 pages. And the DC Circuit went like wildly over its skis and said, well, you didn't discuss the effects of climate change enough. And so that, you can't build your railroad. So the Supreme Court took that up and said, like, no, you can't micromanage an agency's EIS, which is an environmental impact statement, which again, really isn't part of our case because our case, they didn't do anything. It's not that they did a bad environmental impact statement. They did nothing. They just pretended the statute didn't exist. So Our case is so basic. So anyway, so we are basically waiting for the judge to decide what to do. At this point, I believe the best thing would be to order an analysis now and to say, I vacate the termination of the Remain in Mexico policy, which the Trump administration should actually welcome because he's trying to restore that policy, but that's tied up in court in
I see.
in the Ninth Circuit.
If the Biden administration's ending Remain in Mexico were vacated by the judge, then it would kind of moot the lawsuit that the open borders people have filed to try to stop Remain in Mexico from being restored.
It would be helpful. So the DHS in its briefing kind of overstated what it's actually done was that, the policies are back. Well, no, the policies aren't back. They're trying to put them back. And we're at the point where the border is lovely, very quiet, which is great. But that happened at the beginning of the first Trump administration. The border was very quiet. But what happens is a lot of people just won't come because they're like, there's a new sheriff in town and I won't come. But you have to set up for long-term success. You have to set up policies that are really going to stop it. So we're at that point where people are scared to come in, but at CIS we take a long-term view, which is, we shouldn't just have a secure border when we've just elected President Trump. We should have a secure border all the time. But
the point here is that the Trump administration would not be burdened in any meaningful way if they agreed to do NEPA environmental analysis to increases in immigration, because they're not increasing immigration.
Exactly.
In other words, in a sense,
really
it's
wouldn't.
almost like an insurance policy for when President Gavin Newsom or President, what's his name, who's going to be mayor of New York, are sworn in, to prevent them from doing what Biden did. And so what I don't understand is why the reluctance to embrace the approach that you have pioneered.
Well, I think the reluctance stems from the fact that the way environmental analysis has been done in the past has been for left-wing causes. And so there's this reflexive, like, well, we don't like NEPA, though. We don't like environmental analysis. Right. We don't like having, say, a railroad that's desperately needed to carry oil be stopped by a court that's out of control because we didn't talk about the climate change effects of that 20 years from now, right? Sure. And that's very reasonable that they don't like things like that. But it's not that that's what NEPA said. It's that that's who's been suing, right? So and I think the flaw in their argument is they think, well, if we say NEPA can be used for something good, then they'll sue us more. And that's a real flaw, because that's
they're suing
not
anyway.
True.
Yeah.
They will sue whether you say there's anything good about NEPA or whether you say, let's just get rid of all environmental regulation. None of it's good, right? They're going to say that it is in the law. It hasn't been repealed. It's been made a little more reasonable in the context of permitting in recent years, but that is not what this case is about. And, in this case, we're really trying to get some transparency for the American people in terms of agencies bringing in lots of people. I think we could see what happened in Gaza last week, where they just started secretly bringing in people who were not going to leave. And nobody knew, somebody had to blow the whistle. Again, like, we should have transparency in immigration. That's kind of the least the American people deserve.
Right. And so in a sense, requiring environmental analysis, the main goal here would be transparency. And I mean, just to respond to a lot of and I want to get to Alligator Alcatraz too, but to respond to the concerns, I mean, I get that a lot of people on the right don't like the way NEPA works. They may hate NEPA altogether, they could be kind of even troglodytes about, well, let's go and, burn everything and pave everything over, whatever. But the point is, the law is there. And if you're not getting it repealed, the question is, should it be and can it be applied to goals or to forward goals that, in our case, in immigration context, we want to promote? And the answer is yes. And so I just don't get why they would resist, for instance, a court settlement that would bind a future administration unless they then, kind of like the Flores settlement in a different context, which you could revisit. Congress could change it. They could restart a lawsuit, whatever it is. But the point is, it's a whole lot harder to undo than just a executive order or some, policy memo.
It is. I agree. And I think it's just that the people in charge of that decision maybe don't understand immigration that well. I mean, I can't speak for them, but
right.
I would say they may bring up the idea of, like, well, this will hamper us in enforcement. Now, I mean, our current head of Customs and Border Protection, Rodney Scott, is a really wonderfully competent individual. He was our expert in our last case.
Expert witness. Right.
So, and he did a fabulous job explaining what happened. And, he wouldn't have served as an expert witness if he thought that going forward, this was going to stop immigration enforcement.
I mean, in a sense, it's almost by definition not applicable, because the whole point is to immigration enforcement is to let fewer people into the country at least illegally, but I mean fewer. And the point of environmental analysis under NEPA is to require that if you're going to let more people into the country. In other words, it's the exact opposite. So I don't want to, I mean, we're going on this long. I want to get to Alligator Alcatraz. There's a lawsuit based on NEPA against Alligator Alcatraz. And I didn't actually know this until we spoke before the recording, that anti-enforcement groups suing based on NEPA against detention facilities is the one thing that INS and now DHS accept NEPA as legitimate. So It's the one thing that they accept, and explain a little more in depth, but the one thing they accept is the thing that hampers what they want to do instead of promoting what they want to do, which is what we're trying to get them to do.
Exactly. And so it comes back from the misinterpretation of NEPA that goes way back, which is sort of like, well, if we build a building, that's environmental, and that's an environmental impact. So if we have a detention center that we've built because we have a lot of people and we need more detention space for them, well, let's do an environmental impact statement over that building of the detention center because we've built a building.
So DHS accepts that as a legitimate basis for lawsuits against itself.
It has, because it's accepted that since 1981, when INS promulgated its NEPA procedures and said, well, we'll do environmental analysis when we build a detention center.
Okay.
So that's not new. And they did continue to do that all along. And no matter how anti-NEPA they are in the context of applying it to growing the population, the anti-borders people are not going to refrain from suing, as we can see.
And they've sued against Alligator Alcatraz.
Alligator Alcatraz because it didn't do any NEPA analysis, and that is true. It didn't do any. Right. And they sued. And a judge, I think where it currently stands is a judge put a stop to expanding the facilities.
Right. It's still being used.
It's still being used.
This was about expansion.
But you can't expand it. And, I mean, I'm not sure you necessarily want to say that's a terribly wrong decision, because after all, it is in a national park. And also, just to be clear, under NEPA, you can still do it. If you want to put a detention center in a national park and pay for the national park, NEPA itself is not going to stop you. It's just going to make you study it first. So
right.
That's really far afield, because that's not what I'm trying to do.
No, I understand. But I mean, the basic point, though, is that DHS does accepts that it should be doing environmental analysis when they're doing pro-enforcement things.
Right. It has long accepted that. Now, that being said, it didn't do it. I mean, it didn't get done in the Alligator Alcatraz
Sure. But I mean,
context,
we're talking.
But it generally accepts it.
The principle is my point here. Is they accept that
NEPA
applies when they're doing something pro-enforcement, but they are now resisting our efforts to get them to agree that it applies if a future administration were to do basically an anti-enforcement.
Yes, I mean, that's
so it is. It's kind of
play.
It's upside down.
It is upside down, and again, what's so upside down about not applying it to bringing people into the country is the whole point of it was really not to stop you from doing the things you need to do because you need to do them. It was to make you think about it at the point when you engaged in a policy that would make you do the environmentally significant thing in the first place. So, like, if we decide we're going to create a new program that brings 100 million people in over the next 20 years, that's the time when we really should be thinking, and when it's not burdensome.
Before you do it.
Before you do it.
Right.
To think, do we want to do this? Will it be good? Well, like, what? How much infrastructure are we really going to have to bring in? Are we going to have to build? So it's a great time to do it. Whereas, once you're on the hook, once you've brought people in and they're there, and like it or not, you got to build new schools. You got to update your sewage system. There's really nothing you could do because you have to do those things or live worse. That's not the right time to slow things down. So that's sort of how we've been operating for decades, but we are rethinking it right now. We're sort of a rethinking of NEPA. We've taken away the regulations. Every agency is redoing its procedures. So in my view, this is the perfect time to think, well, it's not that we don't like the concept of environmentally enlightened decision making. It's like, let's do those thoughts and analysis and transparency at the best time we could for the American people, and then not hold up things that just need to get done, such as permitting or roads that just we seriously need because they're decayed. So that's where I am, and I hope people are willing to spend a few minutes to rethink their position on it. I think that would be great for the people, but in the meantime, we'll just keep trying to apply the law.
So this new lawsuit that we filed in Texas, since we won the lawsuit, which still the administration hasn't, we don't know what the remedies are going to be, and they're kind of resistant to doing what is in their own good, quite frankly. What would this new lawsuit filed in Texas do? In other words, is it just sort of one more thing? I mean, in other words, what would be the difference?
Well, what we've done is we're suing on different actions.
Okay.
Same theory, same basic theory. We're still suing on the termination of the Remain in Mexico, which, as I said, is still in fact in existence because the courts have tied it up.
It's a new lawsuit, but it's not based on new policies.
It's not based on
the Trump administration did. It's still based on Biden policies.
Biden policies that have not gone away yet.
Right.
So there's also regulations such as the asylum rule, which is still in effect because you can't just undo a regulation. And the asylum rule, again, was part of the program the Biden administration engaged in that was a comprehensive program and admitted to be a comprehensive program. They even had a Federal Register notice where they named the actions we've sued on and said these were meant to work together to bring in more people.
Exactly.
And we also sued on the grants that were used to fund the project to NGOs. So, and that is something that just absolutely needs to have more transparency. I mean, so NEPA also applies to federal funding of infrastructure. And this is basically saying your infrastructure of migration into the U.S., because what they basically did was they created a pipeline of people from all over the world into the U.S.
Sure.
And it's metaphorically, it's a pipeline, it's infrastructure. They even, I think, called it infrastructure in one of their lawsuits, saying the Trump administration couldn't stop them from getting their funds, which is another reason why it's still live, is because we're really in this situation where the left keeps suing and saying that the Trump administration can't undo what Biden did. And we're in this situation where there's a ton of process needed to undo anything that has to do with bringing people into the country. There's process because the left sues over it, and there's process because every time you deport someone, there's a level of process you give them. So
whereas if a judge vacates those Biden policies, there's no longer really a basis to defend them because they no longer exist. Is that kind of the thinking here? In other words, if a judge retroactively vacated them, then that would reduce the opportunities.
Say, that's to be determined, because I would also say that the policy of not doing NEPA is still in effect. Again, the Trump administration has not changed its mind that you could bring people into the country without any NEPA process whatsoever. And that's ongoing. And again, the judges are picking what the Trump administration and the judges are picking at small undoing or freezing or keeping small parts of this overall policy that the Biden administration created,
Right.
which was basically a population increase, a foreign population increase program.
And so our contention is the entire enterprise was illegal because they didn't do environmental analysis.
They didn't do an environmental analysis. And we're still there. We're still there. Again, part of the problem with and part of the reason why there are exceptions to these doctrines is that when you're litigating, it's hard to have something remain from front to center to the end of litigation, because if it's mooted out by the time you get to the end, you'll end up never being able to get to the merits and get a judgment and get it fixed, because, and I mean, I went through this with the first Trump administration. You get a new political wind shift, you get a new president in, suddenly everything's back and you have to start from scratch. And I've been litigating the case in DC for more than 5 years now. And that's more than the length of an administration.
Right.
So there are some exceptions to that as well. So that's what we're doing. I mean, it's not easy to affect change through litigation, but it might be the only way to do it. It might be the only way to make the laws that were meant to protect the American people actually do so, which is what I want to do in the long term, because we may get another president, just as we did after the first Trump administration, who has a polar opposite view of immigration. We don't know. I mean, I hope not, but we don't know.
Right. Yeah, exactly. So I want to wrap this up, but the punchline is, so far, the Trump administration hasn't sort of decided on embracing NEPA, so long as it exists, as a way to lock in its preferred policies, or at least to preclude future unraveling of what they're trying to do. In other words, there's always, Congress could pass statutes, but they're lucky to name post offices at this point. So it seems to me litigation is an insurance policy for preventing the reversal of a lot of the gains we've seen over just past 8 months.
At least the reversal without the statutory due process. And the reason why they ignore the law is it makes it easier. I mean, I think why did they build Alligator Alcatraz and just ignore NEPA in this case? Well, it was easier to do it without, I mean, it's easier to take action immediately without thinking about the consequences. And the same is true for actions that unsecure the border. And yes, and in fact, I mean, the irony of the Trump administration's current position is that it actually does indeed acknowledge and do NEPA analysis in times when it's doing enforcement. It actually did do an environmental assessment for its attempted but not done yet, a restoration of the Remain in Mexico policy. It did a NEPA assessment.
Oh, really? Okay.
Yes, yeah. And indeed, it even admitted in its NEPA assessment, this is a temporary policy. Now, it didn't do anything like what we're saying is the thing being ignored. It continues to take the position that no matter what, it will never do an environmental assessment of the population increases. In fact, it even said so in its briefing. It said, we don't have to do an analysis, because even if the judge forces us to do an analysis, we're not going to do anything on population because we don't have to, and we refuse to do it. Which, that's a question that isn't in our brief now, because the question is not, did you do a good analysis, but did you do any? But it's interesting that the Trump administration is basically saying, we'll do it if forced. I mean, and for instance, for the wall, they agree that NEPA would apply to the wall without a waiver.
Yeah,
that's
but
why they took
Congress allowed a waiver there. That's not even an issue.
It's actually becoming more of an issue now, because there's a new lawsuit against the wall. And it says that the delegation doctrine has been changed by the Supreme Court. The delegation doctrine is what allows Congress to say, right, we don't have to specify what you can waive NEPA for, just any time, you get to decide. And so they actually have a stronger case against this waiver because of the new precedent than they did last time. Now,
but so this sounds to me like another example of the Trump administration acknowledging the applicability of NEPA to the things that it wants to do,
yes.
like expand the wall and expand detention, but rejects the applicability of NEPA to the things that it's not going to do and the left wants to do, which is increase immigration. So
that's where we are.
I don't want to go.
That's actually where we are.
Yeah, so, we need to end this. But yes, the point is, I get the sense that the administration in this context can't take yes for an answer. They're not acting in their own interest and in the long-term interest of the policies that they're genuinely in favor of, which is at least putting roadblocks in the way of a future administration doing what Biden did over the past 4 years.
Yes, exactly. Putting roadblocks in the way of, they'd still be able to do it, but the citizens would be able to sue. They would have to take more of a political hit because they would have to admit what they were doing if NEPA applied, which is fundamentally what NEPA is for. Yes, you still can do it, but you can't just do it without acknowledging what you're doing.
Right.
So
let me, we'll end it there. Obviously, this new lawsuit in Texas may take another 5 years. Who knows what? This will keep you employed for quite a while. And there may be other things that we're going to do down the line, and we'll talk about those if and when they happen. But especially if there's a new development in the lawsuit that you won last year. In other words, there's some ruling from the judge about remedies or whatever it is, whatever happens, we'll talk about that when that happens. And in the meantime, thanks for coming in.
Thanks, Mark.
And finally, just a word on the president's recent comments that he wants to double the number of Chinese foreign students and let in 600,000 foreign students from China. I mean, it's kind of bonkers just on its face, but there are several wrinkles to it that matter. First of all, there's no limit on foreign students. There should be, in my opinion, but there is no statutory or regulatory limit on the number of foreign students. So colleges could take in 600,000 Chinese foreign students tomorrow if they wanted to. And obviously, then there's the other aspect of it is that this is a significant national security vulnerability, even the number we're letting in now. And in a number of aspects, both in a strictly kind of geopolitical aspect. In other words, we're taking in people who are either themselves spies or have family at home and are pressured and can be pressured to engage in espionage, but also just the industrial economic side of it. There's constant stream of stories of Chinese students and researchers who are arrested for stealing business secrets, stealing technology, not even militarily specifically, just generally of economic importance. And everybody from China is vulnerable to that if they have relatives back home, if they want to return home to China. So even if they're not actually working for the Chinese, the People's Liberation Army, the Chinese military, or its various intelligence agencies, they nonetheless can be bent to the will of China. And China is, let's face it, we're in a kind of Cold War with China. They are our primary geopolitical opponent in the world. And the idea that we should be training their elite, even if there were no military, strictly kind of political military aspect to this, if it was merely an issue of their stealing business secrets and new civilian technology, it would still be a bad idea. But also, obviously, there's theft of militarily relevant technology. So broadly speaking, the issue of foreign students needs to be rethought altogether, whether from China or India or anywhere else. And we need numerical limits on foreign students. We need limits on the percentage of any institution's student body who are foreign students. I mean, the idea that we learned after 9/11 that these flight schools were importing foreign students from the Middle East who then learned how to fly planes. They didn't practice landing them, but they studied taking them off, should have woken us up to the broader issue of foreign students. And even specifically with China, somebody I was speaking with recently made a really interesting point, is that the Chinese are the main suppliers of the precursor chemicals for fentanyl. And they know what they're doing. I mean, this is clearly in their perspective. They see this as a kind of payback for the opium wars, if you will, even though we weren't involved. That was the Brits involved. But it's clearly, there's no real arguing that that's not the way, the historical prism through which they're thinking about this. So the Chinese are responsible for killing thousands of American young people, and yet we're taking in Chinese young people and training them to compete with us economically, certainly, but even militarily. It's just bonkers. It's in the old Superman comics, they had a thing called Bizarro World, where the globe was cubical and Superman was the bad guy. In other words, it was sort of the reverse of everything. This is Bizarro World foreign student policies. And I suspect this was an example of the president just sort of saying stuff. And he does that, and, it's the way it is. He kind of market tests ideas that way. But if this was a kind of market test, it's important that the administration understand that this is even less popular than Cracker Barrel's rebranding, which caused them to cancel that. It's not an immigration thing, obviously, but it's the same kind of idea. Administration needs to hear that this idea of importing hundreds of thousands of additional Chinese foreign students is super unpopular, and we need to put the kibosh on this. So that's it for this week's episode of Parsing Immigration Policy. Thank you for tuning in. Thanks to our indefatigable producer, Brian Griffith, for making this happen. And I hope to hear from you in the future. If you have ideas, suggestions, criticisms, even anything, complaints, email us at center@cis.org. And I hope you tune in next week.